that today we have a president of our country saying that because the matter is pending in the Supreme Court, I will not exercise my constitutional powers, right? To assent or refuse assent of a bill because the matter is pending in court. And the judge says, yes, you have filed it, but I will still go ahead. And if the Supreme Court holds me in contempt, I'll come to... Please, I thought that
basically
left much to be desired.
So basically they were seeking to arrest the ruling so that she doesn't deliver.
Exactly.
Okay.
Number two,
yeah.
The judge was terribly wrong when she said that there is no statute that confers on her jurisdiction to give orders for inquiries, mistrial, and so on. Because Article 140 of the 1992 Constitution is clear.
Criminal law.
Yes.
Criminal law.
The High Court.
Criminal law.
Yes.
Criminal law derives from the law itself.
Yes.
The judge's jurisdiction must be statute-based.
Yes, I'm coming. So let me read to you.
Should we debate this?
Yes, and I'm trying to tell you that there is statutes.
No, you are reading article...
Hold on.
You are reading the Constitution on general jurisdiction for the court to exercise.
Hold on.
Yeah.
The High Court, 141, shall, subject to the provisions of this Constitution, have jurisdiction in all matters, and in particular, in civil and criminal matters, and such original, appellate, and other jurisdiction as may be conferred on it by this Constitution and any other law. So the Constitution grants the High Court jurisdiction in all matters, civil and criminal, subject to the provisions of the Constitution.
Fortified by statute. It said there, right there, fortified by statute.
No, where is
the statute?
statute?
That,
where? There is no statute here.
That delimits the
There is no statute or any known law that says that a court, number one, cannot exercise general jurisdiction in criminal matters or inherent jurisdiction in criminal matters. So you allow me to make my argument. I'm saying that 141 doesn't talk about any statutory jurisdiction. It says that the High Court shall have, subject to the provisions of this Constitution, have jurisdiction in all matters and in particular in civil and criminal matters. Now, there are decided cases on this, right? Decided cases. If you look at the case of Republic versus High Court, Kufuridua, S. Party Nyame, and another, right? The court was clear. This is what the court said. Nothing was presumed to be out of the jurisdiction of the superior cause unless expressly so stated. But nothing was presumed to be within the jurisdiction of the lower cause unless specifically stated. I can go on and on and on. Now, this is the point. Once the Supreme Law of the land has given you general jurisdiction in all in all matters criminal and civil, our contention is that unless, based on this decision, a law expressly takes away or outs that jurisdiction, you cannot say you don't have jurisdiction.
She points to the provisions of the criminal and other offenses.
Which doesn't apply to the case, Section 8. Which doesn't apply.
Which pertain to jury trials. And she says, no, mistrial in any case happens in jury trial.
This is not true.
This is not a jury trial.
Let me even show you why it is not true.
Say you disagree.
I disagree. The reason why I disagree is that even apart from the general jurisdiction she has, and on the basis of the decided case the authority have cited, shows that until that a law expressly takes away or outs that jurisdiction, she has to exercise it to do justice. There is such a thing as the common law, which is part of the laws of Ghana. Article 11(1)(e).
And common law must not be mounted for criminal...
No, there is no law. What the law she cited says is that you cannot prosecute and convict a person under the common law. We're not asking for Godfred Dame to be prosecuted. We are asking you to make orders subject to the common law. That is what Dr. Bassett asked. And this is the point. It is very clear, and I can cite another case to you, okay, that every court, especially superior courts, let me put it that way, has inherent jurisdiction to provide for matters not even provided for in statutes. And if you look at the common law, courts trying criminal matters have inherent jurisdiction to prevent the abuse of their processes, the processes of the court, and to ensure fairness in the legal proceedings. Some of you understand. And in so doing, under the common law, courts trying criminal matters are able to make orders for inquiries orders for mistrial and so on. And that common law per Article 11(1)(e) is part of the laws of Ghana.
Okay.
Aside that, there is Article 12(1), which enjoins all organs of states to uphold the fundamental human rights of all citizens or all persons in Ghana. 19 talks about the right to a fair trial. Article 142 gives the High Court jurisdiction to enforce fundamental human rights. And then you cannot say that if in the course of hearing a criminal matter, the right of an accused person to a fair trial is being violated, the court will not exercise inherent jurisdiction to prevent that abuse of that right. Again, the court got it terribly wrong in assessing the evidence that was placed before the court. Who can listen to this audio you have played this morning and say, in good conscience, Samson, that Dame did not ask Jakpa to implicate Ato Forson? You hear in the tape at several points Dame telling Jakpa to testify his way, and that was not going to create any difficulty for Jakpa. What was going to be the effects of those testimonies or answers he was soliciting through that unprofessional way from Jakpa? If Jakpa went to court to testify the way the AG wants, i.e. saying that payment was made via letters of credit even before goods were shipped, was that not going to implicate Ato Forson for willfully causing financial loss to the state? The judge makes no reference to those portions of the tape. Then the judge goes to the part of the tape where Jakpa is heard saying that if I do this, I will be dishonest. The judge says those were the words of Jakpa. But
that's true.
Yes.
That's true that those were the words of Jakpa.
Yes, but in assessing evidence, you assess it, number one, as a whole. Number two, a judge is allowed to make inferences in assessing evidence. And so if in a conversation, I tell you, Samson, that you told me to go and implicate somebody, and that if I do that, I will be dishonest and I will be sending an innocent person to jail, and you have not done it, what is a reasonable person, any right-thinking person will do? Deny. Dame never denied. The only thing Dame said, that this is a telephone conversation, I don't know whether I'm being recorded. That statement in itself shows that Dame had an ill mood.
He hasn't said...
And the judge is saying...
Wait,
no.
Dame hasn't said this, but let me play the devil's advocate again.
No,
hold on, let me tell you this. Let me tell you this.
Yes, where the court has done it right, we have the right to commend it, in our opinion.
Sammy,
hear
me.
Express our divergent opinion.
Sammy, hear me. And last week we went through this, and many people came at me that I'm heckling you. I'm getting the best out of you.
No problem.
Now watch this.
That's that you must give me the time to...
And for you who think this way, I have no any such intentions.
Yeah.
Now, Dame has not said this.
Yes.
But imagine when they say the tape has been pieced together.
Yeah.
It is possible that where you are expecting the judge to make an inference, that inference could lead into trouble when there is the full audio provided somewhat, and it shows that he had protested that comment, and yet that was cut off.
Senior, respectfully, that is a red herring because the judge herself, Dame herself, did not raise any issue about the incomplete nature of the tape. And the judge never made any reference to any incomplete tape. You understand? So that was not even one of the things she considered. In this case, ask yourself, why did Jakpa say on the tape that I cannot help you, and that if I testify the way you want, I answer the questions the way you want, I will be helping you to convict an innocent person? It is because prior to that, the Attorney General had told him that, look, this is very simple. If you do this, if you agree to this, it won't create any problem. Then he replies by saying, I can't do that because if I do that, I will be helping you.
So
then
bottom line,
and says,
we need to move on.
No, then he continues and says, I have been having several meetings with you in my cousin's house. Dame doesn't say, no, I've not been having meetings with you. And the judge says, because only one party on the conversation said this, then it is not true. And he, my senior at the bar, Kagari, and the judge, they say that, oh, this is a tape that only made 2 weeks ago. Really? The tape contains evidence of interactions with Mr. Jakpa that happened as far back as 2022, the outset of the case in court. And if you look at Jakpa's affidavit before the court, he speaks about interactions with the Attorney General as far back as 2022, for which reason he says...
Hold on. Gary's question is, why didn't he bring that in the process?
For which reason, Mr. Jakpa says the whole case has been brought in mala fide and not bona fide. Why didn't he raise it at the beginning is neither here nor there. Jakpa is now doing his case. Ato Forson has not been in meetings with Godfred Dame. Jakpa is now doing his case, and this is the right time. Now, let's make something clear for those who are learning.
I need to move on.
Because sometimes you ask a certain question which may give a wrong impression. Godfred Dame has not been acquitted of any charge of misconduct.
Godfred Dame has not been charged with any charge of misconduct.
Yes, and he has not been acquitted. What the judge said at page 8 was simply to play Pontius Pilate. That my forum is not the right forum to pursue issues of professional misconduct against the Attorney General.
That you agree,
and that there may be another forum.
That you agree, don't you?
I disagree because the court is also a forum. The two are not mutually exclusive.
A forum for punishment for misconduct.
Every superior court has an inherent jurisdiction to ensure that, number one, its processes are not being abused.
Even in the Supreme Court.
Yes.
When Nekwe Tete's matter came up,
yes,
the court had to make a referral to the General Legal Counsel.
I'm talking about a prosecutor.
They didn't punish.
Look, you are saying that if a prosecutor, in the cases, the Canadian cases and the Senate cases the judge cited, what was the substance of the case? What was the issue? It was about prosecutors prosecuting people for crime, engaging in misconduct, and those courts being called upon to say that, look, your processes are being abused, accused persons are not likely to get a fair trial, therefore invoke your inherent jurisdiction to prevent that and to protect the rights of the accused person. You can't say that a judge in a superior court trying a criminal matter doesn't have that inherent jurisdiction. And so something finally, what I will say on this matter
in a minute
is that for Godfred Dame to be strongly advised by a judge as Attorney General to stay away from a criminal matter he is prosecuting, and the judge gave her grounds. She says, I strongly advise you to do so to protect justice, and so that the public will have confidence that matters before the court are only determined in the court and not elsewhere. This is the most damning verdict ever given by a court against any Attorney General from the days of Godfred Dame. And it shows what a disgrace Godfred Dame is. And this is the more reason why he must go. And if he doesn't go,
the application to prohibit the judge